Well, welcome everyone. Thank you so much for joining us today. We're really happy to spend the hour with you. I think that we've got some really great information to share with you all today. So thanks for spending your lunch hour with us. My name is Rachel Schrader. I'm PPMD's Vice President of Clinical Care and Education. And I've got two fantastic speakers with me today. I have Amber Sapp, who is a physical therapist by training and a Duchenne mom, who has some really great insight and experience when it comes to thinking about financial planning for your future and for your family. After Amber shares some of her experience with us, we're also going to hear from Leona Filis, who is an attorney at the Filis Law Firm, who specializes in special needs families and planning for their futures. So at this point, I think we'll go ahead and just dive right in. I'm going to turn things over to Amber, who is going to share with us a little bit about her experience not so long ago in navigating some of these pathways in her own house. Amber?
Thanks, Rachel. Hi, everyone. I'm really glad to be here and talk about this topic. It's something that really had been on our family's mind for a long time and something that we just kept putting off because it's not really fun to think about, your death and your husband's death and how that affects your family and how to plan for your kids. But it was definitely something that weighed heavy on us. Anytime my husband and I traveled alone together, I would make these lists for whoever kept our kids. And we always told ourselves, we're going to take care of this. We're going to put this on paper one day and make sure things are squared away. And so finally last year, we really just bit the bullet and finally started the process. And for us, it started with our financial planner. Just talking to him, he knew sort of what our financial situation looked like as a family. And we just asked him some recommendations to help us find an attorney who was well-versed in financial planning and special needs planning specifically for special needs trusts. So for a little background for myself, I have a 14-year-old with Duchenne. So in my mind, I'm thinking, I'm always thinking ahead toward keeping him eligible for SSI benefits. And so, I knew that was coming up at 18. And so I wanted to make sure I had enough time to make sure he didn't have name, and because I knew that some things would disqualify him. And so those are some really good conversations to have with your attorney. And I think that Leona is going to talk about that a little bit. But in order for us to make some steps toward planning, we met with a lawyer. And of course, it's during the COVID world. So a lot of those things happen virtually, which the lawyer we met with was really great to be flexible with that for our first few meetings. And he really just got to know us and our situation. And in the process, it kind of started with us writing our will. Like, we didn't have a living will. We didn't have a last will. None of that was in place. We're both around 40 years old. And so those are things that we should have thought about before now, but we didn't. And so that process started for us. Like, what does that look like? Who becomes the custodian of our kids once we're gone? And so those are things that I think you should begin thinking about. I think immediately people think, well, my parents will take our kids. And that's a really simple answer for people with typical children. But keeping in mind that what goes along with Duchenne in the future and the burden that, I use burden lightly, but the burden that goes along with that, and making sure that the person you designate to take over in your absence is able and willing to take on all that goes along with that. So, before we decided to have my parents take that role, we actually talked with other Duchenne families that are in our same situation. So that may be a good idea too, to just talk to other families, and maybe they're also looking for that person to take over in their place. And maybe that's a role that you guys can share for one another. So that was something we'd considered. In the end, we ended up making my parents that person. And Leona, please tell me the word that I should be using. What is the word that my mind is blank? The person who is it's not the trustee, it later on becomes the trustee, but
probably guardian.
Guardian, thank you. So the guardian is my parents in our case. And so once we got our will sort of written and signed and all of that worked out, then we started thinking ahead toward the special needs trust. And for us, because our son is under 18, we opted to go with a third-party trust, which means that we can make contributions to the trust It does not affect his SSI status because it's not in his name. It's not monies that are in his name. So I'm sure that Leona will talk about a couple of different options. That was the best way for us to go. There are things like ABLE accounts that she will probably discuss, and first party trust, but again, we opted for third party trust. So now when grandparents decide to give him money to put ahead toward the future, it automatically goes into his trust. So that was sort of our experience. I think it probably took us 3 months to finalize everything. Maybe it was that long because I dragged my feet a little on making some of those decisions. As a medical professional, I really sweated out some of the details on my will, and am I sure I want this? Am I not sure I want that? And but those are good conversations to have, because it's easier to have them now when you're healthy, and than when it's a tough decision and your spouse is making those. So yeah, if anyone has any questions about our experience, I'm happy to elaborate or talk further on that. Leona, do you want to take it from here?
I'm going to jump in really quickly and just kind of emphasize what you just said, Amber. During the second half of our hour together, we are going to transition to a question and answer format. So if you have questions specifically for Amber, based on what she's shared with us just these last few minutes, or if there's anything that Leona shares that you want to ask about, shoot that question into the chat function at the bottom of your screen, and we'll be sure to dig through as many of those as we can once Leona is finished with her slides. So Leona, go ahead and take it away.
Oh, okay. Thank you, Rachel. Thank you, Amber and Amanda and Stephanie and everybody with PPMD. Phyllis Law Firm here. We're so excited to share what we know with everyone, and especially on this format. We were talking earlier about how great it is to be able to share with everybody, whatever state you're in. We're in Texas, so I will be talking about different things that affect us here in Texas, but should be applicable throughout the United States. So I'm going to share my screen, and I have some slides. And I will start. So typically when we have a client come in like Amber and they want to go ahead and start talking about their estate planning, if they have a child with special needs, we want to make sure a lot of the issues that are or challenges that our families face are addressed. So we ask people if they've signed up for Medicaid waiver programs. We've talked to them about special needs trusts, getting sufficient life and disability insurance, updating or obtaining a will, medical power of attorney, regular power of attorney, talking about a 529A account, and then possibly guardianship or lesser restrictive alternatives. So we try to, just kind of give a little bit of a plan for families to think about for all these different things that they can do on their own or with an attorney. But the main thing that we wanted to talk about is the Supplemental Needs Trust, also called Special Needs Trust. And why do we need them in the first place? And so for a lot of us, we've heard of these Medicaid waiver programs. So these are programs that are put together by your state and federal government. And what they do is they offer support and services to individuals with disabilities. Different programs highlight different benefits and may have different eligibility requirements. But for the main part, it's for children and adults with disabilities, and it's free services, it's free therapies, reimbursement for home modifications, just different ways where you can get help for your child to get their situation a bit better. One of the issues, though, is that Medicaid waiver programs have interest lists or waiting lists, and the wait can be several years. So what I typically do when I'm on Facebook and I hear about someone asking questions in one of our parent groups because they just had a diagnosis for their child, I ask them if they've heard about the Medicaid waiver programs, and I send them whatever information I can, because it's just a couple of phone calls, but it's getting their child in line to receive benefits, even if it's going to be a few years. So in Texas, we have about half a dozen different programs, and I have them listed here. But the first one that you probably would become eligible for if you put your child on the interest list is called Mdcp, Medically Dependent Children's Program. And for some of our Duchenne families, this particular program is the one that they use forever. You can only be on one program, receive benefits for one program at a time. So you may come off the list for Mdcp. And then be eligible for CLASS, Community Living Assistance Support and Services. But you may not want to transfer to a different program if all of your child's needs are being met by Mdcp. For my son, he's on the autism spectrum, and for fun, he also has ADHD. And we have him on the interest list for the Medicaid waiver programs here in Texas. And he did come off of the Medicaid waiver program interest list for Mdcp. And we received our letter from Health and Human Services Commission, and they let us know that we could have an appointment to see about his eligibility for that program. But for my son with autism, he really wouldn't qualify. He's not medically dependent. So I just asked at that time for my son to be put on the bottom of the list. And we're still on all the waiting list, and we will hopefully come off the list for CLASS. But just to give you an idea of what's involved with these waiver programs in the state of Texas, just in 2019, we have these columns that list how many people are being released and receiving services, released from the waiting list and receiving services from these programs. The very last number in the bottom right is important because this is how many people are on all of the waiting list waiting for benefits. And so we're at, as far as November 19, 2019, we're at 285,000 kids that are waiting for benefits. Last year, we also had a significant increase in the amount of people that are being placed on the interest list and waiting for benefits. And that total number is 305,000. So just in the last couple of years, the interest list waiting, the people that are waiting for benefits on these interest lists has increased over 41,000. So once you get a diagnosis for your child, please make the phone calls to go ahead and receive benefits, or at least get on the interest list to receive benefits. So on Mdcp, if you're in Texas, you would call what's called Health and Human Services Commission. It used to be known as DADS, Department of Aging and Disability Services. It'll be different in each state, but we have an 877 number for people to call to get on these interest lists. So for Mdcp, it is for children, so the applicant would need to be under 21. And then they would be needing to be eligible for SSI. So there's a test. Some of these programs for eligibility look at household income to see if you would meet the SSI test for income and assets. But for most of these programs, and it's different for each state, household income is not a factor. Frankly, when I first heard about these Medicaid waiver programs, it was when I just had the diagnosis for my son. I had a lot of things going on. I was trying to get doctor's appointments in order. I was trying to meet with schools to see what benefits and services we can get from the schools. And then I had a consultant that was talking to me, and she had said, you need to get your son on the Medicaid list. And I just, she probably said Medicaid waiver program interest list. But all I heard was Medicaid, and I thought, I'm not eligible. I'm not even going to waste my time because I need to focus on so many other things. But that's what the point of these programs is, that they waive certain eligibility requirements that are with traditional Medicaid. So household income won't be a factor. Now your child's income and assets will. Let's see. Going back to the importance of how you need to get your child on these interest lists, whatever state that you're in. If you look at this chart, you're going to see that for class, that's the program that I think my son would benefit the most from. You can be waiting 14 years. So on the far left column, those are the years ranges. And you can see for close to the center, we have Mdcp. So you will come off of the list, or your child will come off the list within the first maybe 4 or 5 years. But if they don't meet the criteria to be determined as being medically dependent, then just ask to be put back on at the bottom of the list and keep on waiting. But as you can see, I think the worst wait is going to be 14 to 15 years with HCS, and then 17 to 18 years with Texas Home Living. So we do stress that our parents go ahead and get on the interest list. When you are on the list and you come off of, let's say, the interest list for Mdcp, some of the benefits that you could receive if you're a resident of Texas are listed here on the slide. So you might get help with respite care. You may get funds to help pay for a personal care attendant to come to the house and give your caregiver parent a little bit of a break. Even if you're just going to direct them to help you fold the clothes and maybe go grocery shopping, it can offer you some relief from addressing all of your daily challenges on your own. There are also, you do have the ability to have minor home modifications. Some of you may need ramps installed, and so you can get some benefits from these different programs. Class, again, is one that I think a lot of parents with children on the spectrum gravitate to. With class, again, we don't look at the parent's income or the household income for eligibility purposes, but class will offer specialized therapies, which I think makes it stand us apart from all the other waiver programs. Some of you have benefited, your children have benefited from aquatic therapy with no resistance or little resistance, while some people enjoy the music therapy for their anxiety. Recreational therapy, massage therapy obviously will do wonders for a lot of our kids. And so if you're in the Houston area and you're in Harris County, your local authority, who also administers some of these Medicaid waiver programs, would be Harris Center. And I have their number up here at the top of the screen. Now, the Harris Center will administer some of these Medicaid waiver programs and also offer different benefits to people. But some of their programs that they offer have eligibility requirements that are based on income and assets. So let's say you come off of the interest list, because I know Amber had said, waiting till your child's 18 to get on traditional Medicaid and SSI. But let's say your child comes off of the interest list before they're 18 and they qualify for, let's say, Mdcp. That comes with Medicaid. And once you have a child that's on Medicaid, or anyone in the household that's on Medicaid, if you have, let's say, one of the parents works outside the home and has employer provided insurance, we have a program in Texas, and I believe every state has some equivalent. In Texas, it's called Get Hip. And what it does is, this is a program where if you have someone in the household that your insurance covers that receives Medicaid, you can ask and receive every month a reimbursement check for your health insurance premium. So the state would rather pay a steady premium amount, and this is the whole premium that's out of your pocket, not just the portion of the premium that covers your child. If your child comes off of the Medicaid waiver program, receives benefits from Mdcp, and has the Medicaid, then you can also get reimbursed for your insurance premiums every month through this program. Because again, the state would rather pay the premium at a set amount every month than whatever therapies Medicaid may cover. You would still be able to use Medicaid if it's a program, if it's services that's not covered by your private insurance. But this is, again, another resource for parents when they're looking at getting their child on the Medicaid waiver program interest list. So you have your child on the list. You're also looking at the future where your child may be eligible for SSI and Medicaid after they turn 18. You would want to protect their eligibility for these programs, for these benefits, by not having them have any assets in their name. And as Amber alluded to, we would want to protect that child and their eligibility by having a supplemental needs trust. So that's why we have a supplemental needs trust. We have a couple different variations. We have a first party special needs trust, which is also called a self-settled, and we have a third party supplemental needs trust. So the variation, it depends on the source of the funds or the assets that are going to be put into the trust. So for example, if you have a divorce, and you have, like we do in Texas, the ability to receive indefinite child support for your child with special needs, because they will need assistance for the rest of their life. Social Security Administration will look at that indefinite child support and deem it as income against the child. So when their SSI comes around and they have the child support that's paid not to them, but on their behalf, that will reduce their monthly benefits from SSI. So one of the ways that we can protect that in, let's say, a divorce decree is to make sure that there is indefinite child support and that it's paid to a first party, a self-settled supplemental needs trust. One of the issues that I have with first party special needs trusts is that Medicaid or Social Security Administration has the ability, after a child passes away, to be able to go into the trust and pull out money from the bank accounts to reimburse the state for the Medicaid payments that they've made over the child's life. So there's a payback provision in a first party special needs trust. So I recommend to my clients that you go ahead and you spend the money pretty much down to spend the money in the account every month, that there's no reason to hold on to any money in a first party special needs trust. But for our purposes, for the financial planning, for your wills, for your 401k accounts and retirement accounts, for your stocks, for anything that you have where eventually you would name a successor for in the event of your death, you would want to leave something for your child, of course, but not directly to your child, because then that asset, that cash asset, will count against your child. And if it exceeds $2,000, they're going to lose their benefits. So what you do is you have an attorney draft a third party special needs trust or supplemental needs trust so that your child maintains their eligibility for government benefits. Now, a third party special needs trust is a standalone document. It has its own taxpayer ID number. And typically what I do is when I have parents come in, what we do is we'll have the parents or the grantors and we'll say they contributed, let's say $100 to the trust to create it, then the parents are also the initial trustees. So they will manage the trust assets during their lifetime. And then they will list hopefully 2 or 3 sets of successor trustees, so that in the event something happens to the parents, that child who the trust is for will be taken care of, and the finances will be taken care of, and there's a fiduciary duty involved. So one of the benefits of having a third-party special needs trust, as opposed to what some people think that they want to do, is just pay all the inheritance to, let's say they have 2 children, and the second child has special needs. So some parents think they're just going to leave everything to the first child who will take care of the other one. Well, there's some protections in place in a third-party special needs trust that you wouldn't recognize if you just leave everything to the oldest child. The funds would not be protected if the oldest child had a creditor, a judgment creditor going after them. The funds would not be, may be accessible by a spouse that's seeking to divide half of the assets in their estate. Even if you have a separate bank account, and everybody knows these funds are for younger brother, they're not safe. And then thirdly, again, there's a fiduciary duty to hold people accountable if they're trustee that's named in a third-party special needs trust. So these are some of the benefits of having a special needs trust. Now, part of what the duties are for a trustee is to make sure that certain expenses are paid for from the trust account, and we have a list of a lot of the different allowed expenses that you can pay with trust money. Now, and some people do not fund the trust. They have their wills, they name the trust in the wills, and then they don't fund it until they pass away, and then the life insurance policies will fund the trust. So that's why you need to be very careful on who you decide are going to be the successor trustees. And they'll have an understanding, or they can learn what they can spend the funds on. Another option is a 529A account, also known as an ABLE account. And so this is an option for savings, and it can be used in conjunction with a supplemental needs trust. Now, in Texas, we have, I think you can have a total amount contributed lifetime of $500,000, but you're capped of how much you can have contributed per year. You are also capped at how much of the money in the 529A account is shielded from Social Security, looking at that to see if that's an asset. So if you over time you and family and friends have contributed, let's say $110,000 to your child's 529A account, only that first $100,000 will be shielded. That extra $10,000 will be deemed as an asset by Social Security, and that will exceed the $2,000 maximum for how much you can have as far as value and assets for that child. So then that child's benefits will stop. So you don't want to put too much money into a 529A account, but you can use it. A lot of people use it to deposit Christmas money, birthday money, certain items, maybe for putting money in for a new van for the child. That's fine, and then let it invest. What you can do is once one benefit of a 529A account is that the interest that's earned on the funds is tax free. So for smaller investments, you may want to try a 529A, but for your wills and for inheritance and for retirement accounts, anything that you would name your child as designate them as a beneficiary, use a a third-party supplemental needs trust. Thank you.
Wonderful, Leona. Thank you so much. I don't know about everybody else on the phone, but I'm a little bit overwhelmed by just how much great information there was there. We've got tons of wonderful questions that are coming in. So I think, I'm just going to go back to the top of the list and we're going to start there if that sounds okay. My first question is going to be for Amber. So Amber, you mentioned that you had an attorney help you through this process when your family got the special needs trust. So after going through that process, do you feel like having the attorney's help was really necessary and helpful, or do you feel like you probably could have navigated it on your own?
Yeah, that's a good question. And I feel like I'm really grateful that we went through an attorney. I think they can be very helpful to make sure that you're using funds appropriately. So at the end of the day, Medicaid can't come back and say you didn't use them appropriately, and then they can capture some of those funds. So I think them helping guide you through how to set that up is really important. They made a lot of recommendations for how to set up our trustees and how to sort of divvy up our life insurance funds. So I would not have wanted to navigate that by myself. We read a lot about it, but it was a wealth of information. And so now I feel like I email him all the time and just ask questions like, are you sure that this is how we, and he's just very helpful to say, this is how you can and how you should spend it, just to shield them also and to keep them eligible for Medicaid. So, if you have a third party trust and you spend funds, in an inappropriate manner, I'm trying to think of an example, something that wouldn't be appropriate according to the Medicaid standards, then they can come back and say, part of these funds are now ours. And so I think a lawyer is going to be really good at helping to guide you and make those decisions. And especially for us, so we named, like I mentioned, we named my dad as the trustee upon mine and my husband's death. And so we wrote in some clauses in there that my dad should contact our lawyer specifically before spending any of those funds to make sure he understood the whole process too. So for us, that was really invaluable. So I would definitely recommend going through an attorney for that process.
Awesome. That's so helpful, Amber. Amber, thank you so much. So this next question is going to be for Leona, and it's regarding ABLE accounts. So are employers able to deposit funds directly into an ABLE account?
So there's a federal ABLE Act, and then each state has their own. So it's different. There are different rules for each state. But yes, I have seen where you can. One of the benefits of having a 529 account, a college account, was that you could divert some of your income by having it directly paid into a 529A account, right? Well, the 529 account, college account for your children. So a 529A account is supposed to function the same way and deliver tax benefits to people. So yes, if you were to have your employer directly deposit into the 529A account, then you would have less taxes to pay. So that's an additional benefit.
And I think this question is very much kind of in that same sort of overarching theme about being able to kind of divert those funds. So this is a really good question. So I have DMD myself, and I'm currently Medicaid eligible, and I'm looking at working full time. My family and I have spoken to a financial advisor, and his recommendation was that if I wanted to keep Medicaid while working, that my income should always remain below the income limit for the Medicaid buy-in program in my state. Essentially, he said that I should stop looking for jobs that exceed the income and only look for jobs with an income below the limit. Is this the only option?
That is pretty much what I've been told in the past, is that these programs are to be supplemental. These are to help people who do have indigency. They have indigency requirements. What we do have is, we do have Social Security disability, which would provide assistance to people without having the indigency component. But for Medicaid, It is eligibility is factored by someone's assets and someone's income.
Okay. All right.
So some people they may make, here's something to think about. You can have as low as $1 a month payment in SSI and still maintain your Medicaid. So, there's different calculations that are involved to see what is the best amount you should maybe cap yourself at to maintain those benefits.
Great. Thank you. All right. So this next, Amber, did you want to add anything to that?
I was just going to add one piece of the ABLE accounts. So it's a maximum of $15,000 a year. And then just keep in mind that nationally, a person can contribute $14,000 to that. So a grandparent can contribute to that up to $14,000 before they encounter that gift tax. So that's something, if grandparents are thinking of gifting that, that can be applied to ABLE accounts. The flip side to that is that upon the death of your child who has the ABLE account, those funds go back to Medicaid. So that was another piece that was one reason we chose not to use an ABLE account. So not that they don't have some benefits, but it wasn't right for our situation.
Yes, whatever Social Security has spent during that child's lifetime in Medicaid and whatnot, the Social Security can claw back that same amount out of the account. So yes, you're correct. That is a consideration when choosing if you want a supplemental needs trust or an ABLE account or both.
Wonderful. So this next question, I think, is kind of a natural segue from that same sort of topic. So in regard to families who have grandparents or other family members who want to help fund future needs for their relative, do you recommend how or where they put that money aside? And what if grandparents want to include something in their will? Is there anything that they need to be aware of prior to putting in any sort of legal language or anything like that? And maybe Leona, you could start, and then Amber, if you've got any additional comments to add, we could do it like that.
Yeah, practically speaking, I would say that a third-party supplemental needs trust is the way to go. I have seen a will where there was a language in the will to create a special needs trust upon need. So I don't recommend that at all. I recommend get a supplemental needs trust as a standalone document. It's an agreement. So the grantors and the trustees will sign this agreement to create the trust. It's its own entity. It has its own taxpayer ID number. Then yes, I would have, as soon as that's signed, I would put out a very big email to all the friends and family and say, look, we've done it. Pat yourself on the back and tell them you've done some estate planning. And if they ever wanted to leave your child money or inheritance, but they were afraid to because they didn't want to mess up their benefits, tell them don't worry about it anymore. Just make sure that they leave it to the third party supplemental needs trust. So that's the way to go. If it's a small amount, then go ahead and put it in a savings account. The whole purpose of the 529A account was we had an individual that was working and they were trying to save money to buy a vehicle, but in their savings account, it was just a regular savings account. Anytime if they exceeded over $2,000, they would lose benefits. So the savings account through the 529A or ABLE account, whatever you want to call it, the whole purpose is for that individual to be able to save money without being penalized. So in your situation, if you are working part-time and you want to save money to buy something, a car or whatever, then use the 529A account. But for a third-party supplemental needs trust, that trust can own assets. It can own cars. It can own houses. And with Medicaid planning for elderly people, it's a little off topic, but let's say you have grandparents that might need to go into a nursing home and they don't want to lose all of their, they've already spent down their assets and income. except for, let's say, a $10,000 chunk. But so they want to become eligible and they don't want to have to pay the nursing home if Medicaid will pay for it. So there's a 5-year look back ability that Social Security has to see if you've made any nefarious looking gifts or fraudulent looking transfers. But a gift into a special needs trust, there's no cap on it, and it's not subject for the clawback. So that's a Medicaid planning for an elderly grandparent. So they can contribute to the third party trust. They can contribute to the 529A.
Great. Amber, would you add anything just from your own firsthand experience going through that?
Yeah, so when we wrote out our will, the beneficiaries, we have 2 children. So 50% at this point goes to our daughter, and then 50% will go to our son's special needs trust. And that's something I think that a lot of people think that, okay, I've got my will done and I'm done. But it's really something that every few years you probably need to go back and reevaluate, because, when our daughter is 20, does she need 50% of what was in my life insurance? Probably not. Or, it's a situation that the lawyer had mentioned to us. If you put an age limit in there that says, at 25, your daughter gets, X amount of, what's in there, we hope that this wouldn't happen, but we have some information in there that says if she is going through a divorce, or if she's if she's addicted to drugs or alcohol, if there's some sort of situation that would make her not a good decision maker, we're not going to give her a lump sum of money. So that's the other part of estate planning that we hadn't really considered. We just assumed, well, everybody gets 50-50. But just being aware that after you set up your will, going back every few years and just making sure it still makes sense for your family. And do both of your children still need half of that? Or is your healthy child now independent and no longer needs that? You can put a larger percentage to your special needs trust. That would be the only thing I would add to that.
I agree. What we do in Texas, or what I do, is we have something called a HEMS trust. So we have provisions in the wills. So it says, in the event that there's a beneficiary without a supplemental needs trust, that's not my spouse, and under the age of 30, we want their portion to go into trust. And so you name a trustee in there, and it may be a different trustee than who you have for your third party supplemental needs trust. And you say, look, that trustee has the ability to spend money on health, education, support, maintenance and support expenses. And at age, I do a 3-point distribution. At age 25, they get a third of what's in the trust. And then at age 27, they get half of what's left over. And by age 30, if they haven't figured it out, then that's on them. But that way you can gradually give more finances to your other child or other children, but also make sure that their tuition's still taken care of while they're waiting to hit that age of the first distribution.
I love that. And I want to echo what you said, Amber. You can always go back and reevaluate things. And it seems to be a theme, in a lot of arenas of life, where once you've made a decision, you can always go back and look at it and make sure that it still makes sense. Maybe your family dynamic has changed. Maybe, financial situations have changed. Whatever the case may be, I think it speaks to the need for that long-term relationship with your attorney and your financial planner and all of these important people in your life, so that you can make sure that what you have in place is still the most appropriate choice for your family, even 10, 15, 20 years down the road. So just wanted to kind of bookend that again. So the next couple of questions are in regard to Texas versus the rest of the US. And so the question is, are 529A plans and ABLE accounts both available nationwide, or are those just specific to Texas? And in addition to that, can you have more than one ABLE account?
Okay. So federally, there was the ABLE Act. ABLE stands for Achieving a Better Life Experience. They're also called 529A accounts, because 529 accounts, bank accounts, were the ones where you put money aside for college, right? So the equivalent for our kids with special needs is 529A. So they're the same thing. So Texas does have its own rules regarding 529A accounts, which may vary slightly from other states. But yes, every state has an ABLE Act, which was hopefully been administered and so that the banks in that state can have 529A accounts. There's nothing stopping you from going ahead and investing in a bank account that's in another state. Years ago, when this first started, I think Ohio was the first state to finalize and start up their own 529A accounts. So a lot of people nationwide have an ABLE account in Ohio. Not a big deal, not a big deal at all. What was the second question?
Let me go back and find it. I already forget. Oh, can you have more than one ABLE account?
My understanding is no. It's for one beneficiary can have one account.
Okay.
But anyone, family and friends, can contribute to the same account. And usually you'll have a person, it's not a rep payee, but it is someone who will be on the account with the beneficiary, but it's tied to their social and it's based on their disability.
Perfect. All right, so here's a good question, and I don't know the answer to it, so I'll look forward to your insight, Leona, and maybe Amber, you'll even have some perspective on this one. What do we think about families who aren't able to afford an attorney to help them navigate this process? A lot of families are struggling, especially right now. Are there any good resources or programs out there that could be of help?
Amber, have you looked into anything?
We didn't. I mean, I have some information that our attorney sent us, some detailed language about what each trust meant, what each, just definitions for things, and I'm happy to share that. It's just a booklet, so that may be a first step. I mean, you can certainly set up a special needs trust without an attorney. I think we've talked a lot about how important it really is, but I mean, if that's not a route that you are financially able to take on, then I'm happy to pass along resources that we've gained along the way. But I would imagine that there are some attorneys who do work like that for families. I don't know that it's pro bono, but I don't know, Leona, do you know of anyone who does that sort of work?
Mm-hmm. So another type of special needs trust that we have in Texas is called a pooled trust, POOLED. And we have a nonprofit called ARC of Texas that administers that type of trust. So it is less expensive to set it up. I think the last time I checked on it, it was $600. But you deposit the money into the account designated for your child, and then those funds get pooled together with everybody else that is a account holder. When you're ready to make decisions about spending that money, you go through the ARC of Texas. They manage it. And so you have to get approval before they'll give you a distribution based on the type of expense that you're asking money for. So some people do choose that route. It is cheaper at the beginning to get it formed, to get the pooled trust, but you do have a maintenance fee every month for the rest of the life of that account. So some people don't want to, they're already intimidated or already overwhelmed with everything else that they're dealing with. So they would rather have a pooled trust where they go to some place and say, look, my son needs a new iPad because that's how he communicates based on his speech disorder or language disorder. And so they would request the money from the ARC of Texas and let them make the decision if that would qualify as an allowed expense. But some people want to make sure that they or their family members meet the needs of their children. And so in their third-party supplemental needs trust that they have, they carefully choose who in their family is good with finances, who in their family may be respectful of their own needs and their own the parents' desires, and make sure that their child is taken care of. So it may be a better fit to have a third-party supplemental needs trust for a lot of people, but for some people that are already overwhelmed and don't mind the monthly fee, they should go with a pooled trust. There are attorneys that take installment plans. So if, for us, a big factor is when the child turns 18, when they're transitioning into adulthood. You have a lot of factors you need to look at. Are they going to continue school till 22? Or do we need to start looking at vocational training, maybe a special program at the local college? You also need to look at, do we need guardianship at this time, total or partial guardianship? Do we need to just look at getting our child to sign a power of attorney to let the parents continue to make decisions? So those are expenses. Then you have the supplemental needs trust. Then you have the estate planning for the parents, because if there's nothing in place, at least in Texas, we have intestacy laws. So if the parents pass away, then everything goes to the kids automatically. So then they're kicked out of their programs. So we have to have a will. Well, in the will, we don't want to leave anything to that child that may have benefits from the government. So then we have the third-party supplemental needs trust. So that's an additional fee. Then with parents, what they need to look at are ancillary estate planning documents. What's going to happen? So you have power of attorney, medical power of attorney, but you also have designation of guardian for your kids in the event that you become incapacitated or you pass away. You want to have figure out who would be the guardian for you if you became incapacitated. So there's a lot of things that are going on right around the time when your child's turning 18. Are they going to, in addition to all of that, then you have applying for Ssi Medicaid, collecting all of I think that I had something here. What you would want to collect are all the medical records to make sure that you can substantiate the claim that your child needs assistance, and they cannot work, and they should be receiving Ssi Medicaid. So there's a lot of things going on right around the time the child turns 18. So we talk to our parents. We can file guardianship as early as 6 months before the 18th birthday here in Texas. So we start a payment plan sometimes a year in advance, because the parents want to get everything lined up for their child when their child transitions into adulthood.
That was a lot of good stuff.
Sorry.
No, it was really good. Leona, that actually addressed a lot of the questions that we've got in the chat. And I want to be mindful of everyone's time. And I don't think we're going to be able to get to every single question. We've got time for another couple of them. But as a reassurance to everyone, we are going to push this back out next week along with a companion blog and recap. And I think we'll probably put together an FAQ with some of these additional questions that we're not able to get to today. So if we don't answer your question explicitly, we will get to it in the coming days. So no fear there. And of course, lots of asks for Leona, your specific contact information. We have a large Duchenne contingency in Texas, and I think a lot of folks are eager to chat with you more specifically. But another question that we've got here, which I think is a really interesting one, can you speak to what happens to SSI and Medicaid and Waiver and all of these types of services and benefits if the person living with Duchenne gets married? Are there any implications there that they should be mindful of?
Probably first thing that would come to my mind is introducing additional income and assets. So I guess it would depend on eligibility factors for the different programs. So when the child turns 18, so before the child turns 18, traditional Medicaid and SSI looks at household income. And then when the child turns 18, they're an adult. And so the eligibility is just focused on their income and assets. But then in Texas, for example, we have community property concepts. And so if you add another person into the mix, you then include possibly their income and assets for eligibility purposes. So that would need, you would really want to look at Medicaid estate planning. I know with our elder clients, they can be married, but you know there are certain protections in place for the spouse that's not trying to get Medicaid or not qualify for Medicaid. So there's certain protections that you would want to have in place for that other spouse to preserve some of the community property. So yeah, you would really need to sit down with a planner or an attorney to talk about the different programs, their eligibility requirements, and then what exactly is the other spouse bringing to the table? Do they have their own income? Are they bringing assets? And so those are all kinds of considerations that would have to be looked at.
Sure. All right. And I think this last question is a really nice one to land on and kind of close us out. And I think, Amber, we'll start with you. So the question is, if I'm looking for a financial planner or an attorney who is really qualified and reputable and knows about these types of things, special needs trusts, enable accounts, and planning for families that have special needs, where do you find them? How do you find them? And Amber, what was your experience finding somebody who was able to help you walk through this process?
Yeah, so I think I sort of touched on this. We talked to our financial planner to find out who he recommended first, and so the person he recommended, they work closely together, and they've done several of these already. So they both knew sort of our family, our financial planner that is, knew our family situation, and that's who he recommended based on that. And so we interviewed him before we hired him. And so, you know, we asked him questions about, you know, if he had done this before and what his experiences were. So I think it's important to have those conversations before you really commit to someone who maybe doesn't know all the ins and outs to estate planning, specifically with special needs. And I don't have any particular recommendations outside of just speaking to your financial planner.
Perfect. Leona, would you add anything to that? Are there any networks or organizations that serve as a resource to help people find folks like yourself?
So I am a member of so many groups for autism parents or special needs parents. I get on Facebook, honestly, and I search around. We've also used meetups to focus on finding other families in the area that might have children with special needs, so that we can connect with them. With social media, you have so many options now to reach out and find people. COPA is a COPAA. It's a group for parents and advocates for people with disabilities. So that's a resource. But just do what I did at the beginning and stay up till 2 a.m. researching. But I have a lot of resources on my website also. People that I've vetted. I recommend if you are going to use a financial advisor, ask them if they understand what could disqualify someone for government benefits. That's kind of why we started focusing on legal issues for people with family members with special needs, because you can't have an expert family law attorney, but then they may not understand about indefinite child support and first party special needs trust, and asking for life insurance policies to cover the child support for the rest of that child's life in the event the other parent dies. There's so many other factors that even experts in their fields may not understand if they don't understand the special needs component.
Awesome. Thank you so much for that, Leona. I think at this point, we'll go ahead and wrap things up. The biggest of thank yous to Amber and to Leona both for joining us today. Both of you brought such wonderful insight and expertise to this topic, and I think it's just all been so incredibly helpful. We do have some resources on our website, parentprojectmd.org. You can go to state by state resources. You can navigate to it at the top of the website, and we've got specific resources based on where you live. And of course, in addition to those resources, we recognize that this needs to be shared widely. So this is going to be pushed out next week in companionship with tomorrow's Family Fridays. So now we know what financial planning and trusts and able accounts look like. Now, how do we use those to support independence and independent living into adulthood? So that's what we're going to dive into tomorrow on our Facebook Live Family Friday. And then next week, we'll have the recording of this, the recording of the Family Friday, and an accompanying blog post and FAQ along with additional resources. We can link to Leona's information. She's got some great resources through her website and YouTube channels as well. So thank you so much for joining us, everyone. We really appreciate you spending the hour with us. Apologies if we weren't able to get to your question. We'll try to follow up on as many of those as we can. And thanks so much. That'll conclude today's recording. Bye, everyone.
Thanks, everyone.